Good afternoon, ladies and gentlemen, and thank you very much for your patience. We must start by apologizing for starting 2 hours later than the scheduled time for the briefing. We were just confirming if the decision has been received by the legal team representing the King. So we apologize for that. We had to make sure that they receive it before Minister can announce it to the public. The invite which was sent out today was very clear that the Minister of Justice, Advocate Michael Masutha, who's next to me, will today announce his decision on a petition that has been submitted by the King Dalindyebo on the 23rd of December last week. Minister will take us through his decision, which is in the form of a media statement, after which we'll give you an opportunity to ask questions. Lizelle in Cape Town, are you having any colleagues there?
Yes, there's one journalist, thanks.
Thank you very much. Please convey our apologies for starting very late. We're here now and the Minister is ready to indulge you. Our Director General, Mrs. Nonkululeko Sindane, will be joining us later. She's just running late because of traffic. Minister, over to you.
Okay, thank you, Mthunzi. Members of the media, fellow South Africans, today I announce my decision on a petition submitted by lawyers representing King Buyelekhaya Dalindyebo, in brackets the King, on 23 December 2015. King Dalindyebo is king of the Abatembu tribe in the Eastern Cape. During 2009, he was sentenced to an effective period of 15 years imprisonment after being convicted of various crimes ranging from culpable homicide, arson, assault with intent to do grievous bodily harm, and kidnapping by the Mthatha High Court. On appeal to the Supreme Court of Appeal, his conviction of culpable homicide was set aside. And the sentence was reduced to 12 years effective imprisonment. His attempt to appeal to the Constitutional Court was unsuccessful. He has thus exhausted all legal remedies available to him and is now petitioning me with a directive to reopen his case in terms of Section 327(1) of the Criminal Procedure Act 51 of 1977, the Act. He is currently on bail until 30 December 2015, when he is expected to hand himself to the head of the Mthatha Correctional Center as per the order of the Mthatha High Court. It is important to note that submission of this petition has no bearing on the pending incarceration, as no endorsement was made to that effect in the order of court dated 23 December 2015. Upon receipt of the petition, I received a further request from the lawyers representing the King for a meeting with a view to making oral submissions. I must indicate that although I am not required to hear oral submissions in terms of the relevant section, as I do not sit as a tribunal, I felt it prudent to do so as a matter of courtesy and fairness. I met his lawyers earlier today, and their oral submissions have been considered in arriving at my decision. The founding provisions of our Constitution and the rule of law guide us in discharging our duties on matters of this nature. I have further decided to finalize and communicate my decision at the earliest opportunity today in light of the imminent coming into effect of the court order issuing the committal warrant. This matter has attracted publicity here and abroad because of the position held by the petitioner, the King, and the severe impact caused by the offenses he is convicted of and the sentence imposed. It is for this reason that I elected to communicate my decision on this platform. The petition is based on two grounds, namely that upon the death of one of the assessors during the trial, the presiding judge should have made an order after hearing the parties in this regard. They argue that failure to do so is an injustice and has a bearing on the conviction of the King. The second ground is, in their argument, is that the trial court ignored customary law in its dealing with the matter, and this amounts to an injustice. It is important to state the law relating to a petition of this nature. Section 327(1) of the Act provides as follows, and I quote, "If any person convicted of any offense in any court has, in respect of the conviction, exhausted all the recognized legal procedures pertaining to appeal or review, or if such procedures are no longer available to him and such person or his or her legal representative addresses the minister by way of a petition supported by a relevant affidavit stating that further evidence has since become available which materially affects his or her conviction, the minister may, if he or she considers that such further evidence, if true, might reasonably affect the conviction, direct that the petition and the relevant affidavit be referred to the court in which the conviction occurred," end quote. At the outset, I would like to indicate that when considering a petition in terms of the above-mentioned section, I'm not empowered to act as an appeal or a review authority on the decisions that competent courts have made. My responsibility is to only consider further evidence which has since become available after exhausting all recognized legal procedures pertaining to appeal or review, or if such procedures are no longer available. In coming to a determination, I have to apply myself strictly to the parameters of the provisions of Section 327 as set out above. I have to ensure, therefore, that there is further evidence which has since become available, which, if true, will materially affect the conviction. Of importance in this section is the jurisdictional precondition that should be met before I can act as requested by the King. The petitioner has to make out a case convincing me that the further evidence, if true, might reasonably affect conviction. The issue of, in quotes, further evidence since become available, end quote, as contemplated under Section 327 was clearly articulated in the case of Hussein versus Attorney General, Cape 2, 1988, brackets 4, SA 142, CPD, where the court stated that, and I quote, "As pointed out, the petition to the state president can be brought only if the further evidence has become available, in quote, since, end quote, the applicant has exhausted all his recognized legal procedures of appeal and review. It is In my view, and that is the continuation of the code, for the state president, brackets, currently the minister, just to explain that reference to the state president in this context is the minister, because it was when the provision applied then before it was subsequently amended. Let me start again. It is my view for the state president, and this continuation of the code, brackets, currently the minister, as I said, close brackets, to be satisfied that the evidence has, quote, since become available, close quote, for no application to any court is involved at the petition stage under section 3271 in the matter. I have grave doubts, the court continues, as to whether the evidence in this case has, quote, since, close quote, the failure of applicants' appeal to the appellate division on 24 March 1987 become available to applicant. It was contended by Mr. Mare that it only became available in courts after the conviction and sentence of Kabdi and his gang. That, however, was in 1985. This is still continuation of the code. The statement of applicant's sister-in-law as to what his brother told her of applicant's alleged innocence, albeit after his appeal to the appellate division was dismissed, was something of which applicant was, if true, always aware. It is also significant that in the proceedings before Howie and Berger, JJ, applicant chose not to rely on section 3271. I have quoted from the judgment of Howie J. Continuation with the code. Counsel for applicant referred to the words in quotes has since become available, close quote, and said that the evidence sought to be led now, namely that of applicant, has not, quote, since become available, end quote, but was objectively speaking always available. Hence, the applicant was barred from the recourse to section 327, close quote. It is not part of my function, however, and this is outside the quotation of that judgment, in this application to consider and decide on whether the further evidence applicant now seeks to give has become available to him, quote, since, close quote, he exhausted his other remedies. That is for the state president to do, and I therefore do not do so, save to express my doubts as to whether this is still continuation of the code of the judgment, as to whether I sorry. Pardon me. Can you just bear with me? It is not part of my function, however, in this application to consider and decide on whether the further evidence applicant now seeks to give has become available to him, in quote, since, close quote, he exhausted his other remedies. That is for the state president to do, and I therefore do not do so, save to express my doubts as to whether In any event, the provisions of Section 3271 are now open to the applicant. Close quotes. In his petition, the King, and I return to the reasons for my decision. In his petition, the King states that the trial court consisted of a judge and 2 assessors. During the course of the trial, one of the assessors died, but the judge proceeded with the trial with 1 assessor. The King is of the view that the court was no longer properly constituted and he did not get a fair trial. This ground was never raised at any of the courts that have considered the case, despite the King being legally represented and having been described by the Supreme Court of Appeal as an, in quote, active litigant, close quote. The presiding judge has a discretion in situations where an assessor dies to determine how the trial should proceed. This discretion was exercised by the court in terms of Section 147(1)(a) of the Act, which provides as follows, and I quote, if an assessor dies or, in the opinion of the presiding judge, becomes unable to act as an assessor at any time during a trial, the presiding judge may direct A, that the trial proceed before the remaining members or the remaining member or members of, or B, that the trial starts de novo and for that purpose summon an assessor in the place of the assessor who has died or has become unable to act as assessor. The legislation gives the presiding judge a discretion, if he so wishes, to sit with or without assessors when adjudicating over a trial. Similarly, the presiding judge retains the discretion in the event of death or incapacity of one of his assessors, either to proceed with the remaining member or members, or to start the trial afresh and appoint a new assessor in the vacant position. It is my considered view that the first ground presented does not warrant my intervention for a directive as contemplated under Section Section 3271 of the Act, in terms of which I am being approached. With regard to the second ground of ignoring customary law, it is my considered view that this point once again constitutes an argument on a point of law or interpretation of the Constitution, which only a competent court and not myself as executive functionary is competent to decide upon. In this regard, I will wish to allude to Section 34 of the Bill of Rights, which entitles parties to have disputes adjudicated by courts. In the circumstances, I'm unable to find anything contained in the aforesaid petition which constitutes, quote, further evidence which has since become available which materially affects his or her conviction, close quote, and therefore am obliged to dismiss this petition. I have since communicated my decision to the King's legal representatives, and I would like to conclude there.
Thank you very much, Minister. Ladies and gentlemen, I'll now give you an opportunity to ask questions. We'll start here in Pretoria. The rules of engagement are simply introduce yourself and the media house that you represent.
Francis Mthatha from Progressive Independent News Agency. I just want to clarify something here. As per the Criminal Procedure Act 51 of 1977, Section 327, as said, was the petition to you, Minister, or to the President, as per the Act?
Next question, please. I do not see any more questions in Pretoria. Lizelle, do you have questions in Cape Town?
No questions from Cape Town.
Okay, we have a question from Xolani in Pretoria. Xolani, over to you.
Minister, I just wanted to, Xolani Mbanjwa from City Press newspaper, I just wanted to find out if you are aware that the King, I know these are his private matters now, whether you're aware that the King has filed court papers to extend his bail, and whether you were informed by his team of that. That's number one. Number two, what other remedy does he have now? Does he have any other recourse? And can you also clarify whether the President can still make an announcement of any sort regarding this petition? You did have an explanation. I just wanted to find out some more of whether there is some grounds for the President to actually make a different, come up to a different outcome regarding this. Thank you.
Any other questions? We're all covered. Let me hand over to you, Minister, to respond to the questions.
Yeah, if I miss a point, please take me back to it so that we can clarify it. The petition was submitted as contemplated in Section 3327 as amended. You notice that, for example, in 1997, that section was amended extensively, and there has been prior amendments even before that. I think in 1990 there was also an amendment. It's a section arising out of the Criminal Procedure Act, which itself was initially enacted in 1977, as the name of the act goes. So hence the code, and I was at pains to clarify that a reference in the code that I alluded to of a previous precedent on the interpretation of that section refers to state president. As you know, we no longer have in our constitution the term state president. We now have the term president. But I've clarified that any reference there in that code to state president, actually, in most instances, if not all, now is a reference to minister. So the petitioners have approached me duly in terms of the provision as it currently applies, and in terms of the relevant provision of the Act. The onus lies on me in my current capacity as Minister of responsible for the administration of justice to determine whether I have before me evidence of the kind contemplated there. And that includes the fact that it must be an evidence that has become or has come to light after all the legal remedies have been exhausted. So I hope that clarifies the question as to whether this petition lies before me or before the President. That clause, of course, does provide that in the event I find the petition to contain the kind of evidence that meet the requirements of that section, that then I would then refer such evidence to the trial court that considered the matter to reconsider, and if it's satisfied that it would alter the outcome, can then recommend to the president accordingly. So it's a three-stage process. First, myself, and if I'm satisfied, then the court of first instance, and of course, if the court agrees, then forwards to the president for consideration. On the question of extension of bail, I believe that the granting of bail in the first instance was a decision of court, including the further extension thereof. So that question lies solely within the competence of courts. There is nothing in the law that empowers me to grant any such extension under this provision or any other law that I'm aware of. So I think that it's incumbent on the petitioners to approach a competent court in that regard. The question relating to if there's any other remedy left for the petitioners, let me indicate that the Section 327, as it currently stands, creates no further avenues beyond this point. However, the courts have inherent powers under the Constitution, hence I alluded to the relevant part in the Bill of Rights that says everyone has a right to have their dispute settled by a court or a competent tribunal. So it's the prerogative really of the courts to determine, if so approached, the constitutionality of the limiting aspects of 327 with regard to further recourse following a decision of this kind. And therefore, really, it's the onus is on the petitioners, if they so choose, to pursue any such further remedies that they may believe they are entitled to, despite the limitation in Section 327. I cannot speculate on that. It would be a matter that a court, if approached, would first have to deal with and exhaust, I would imagine.
Thanks, Minister. I'll give you one last round, and I must indicate that after this press conference, Minister will not be doing any one-on-one, so this is your opportunity to ventilate all issues that you feel Minister should indulge you on. This is in view of a possible legal process that you guys have already asked Minister about, of which we have no clarity at this stage. So I think you must take the advantage of this opportunity. This is your last round. Tulas.
Thanks, Mthunzi. Tulas Semelane, ENCA. Minister, two questions, if I may. One is really a process question, and the second is a political question. The process question, earlier on you said that the petitioning, as was done in terms of Section 327 to you, has no bearing on the order of incarceration that was issued. So I'd like you to just amplify that. What is your department's approach and attitude towards King Buyelekhaya Dalindyebo as it stands right now, with the deadline of tomorrow approaching? Do you consider him as an offender duly convicted that should report to a correctional center that falls within your department? So that's the one question. second question is a political question. There's been a narrative that says it would be a tragic day when a democratic government sends a king to prison, as happened in our history, during our colonial history. And I'm sure you're very much aware of this argument that, one version of it says this is driven by, quote unquote, historically privileged whites who want, the book thrown at our traditional leaders and institutions of traditional leadership. So from a political perspective, how do you feel about this turn of events, Minister?
Any other questions? Lizelle, do you have any willing partner in Cape Town to indulge us?
Folder is not willing. No more questions from Cape Town.
No willing partners in Cape Town, Minister. Over to you.
Thank you. Let me first indicate that the matter of the conviction and sentence were entirely dealt with by courts of law. And as you are aware, all appeal mechanisms were exhausted in the process through the courts. The decision was for the courts to make. Maybe I may also just add that whilst I may be empowered in terms of 327 to consider fresh evidence, even in that instance, even if such evidence had come to light and we were of the view that it is evidence contemplated under 327, 327 still requires you to refer such evidence to the trial court, and it would be that court that makes a determination with regard to its relevance and whether it should be taken into account to revisit the conviction and sentence in terms of that provision. So, hence our emphasis in this decision that even the points that are being put forward, which in our view are, strictly speaking, questions of procedure and questions of interpretation of law and the Constitution, which are matters best dealt with by courts, and therefore are areas in respect of which, one, we have no competence, in that we are not aware of any law that empowers us to consider such matters, and that, of course, we do not find them to constitute evidence that has since become available upon exhaustion, etc., of the available remedies as contemplated in Section 327. So, really what we're saying is that at this stage we do not believe that we are favored with the kind of key, if you like, contemplated in Section 327 that would entitle us in law to unlock that door. You want to know, is there available remedy beyond this? I think the implication of that conclusion is that whilst we leave it to the parties to determine whether there are still such avenues to be explored, despite the limiting provision under 327, we're saying we ourselves are not the appropriate forum to actually provide that relief based on the grounds that are being put to us. I hope that clarifies the matter. The question that's been asked as to the political narrative, as you put it, that this is a democratic government which would be faced for the first time with the conviction, sentencing and incarceration of a sitting king. Let me indicate that Section 327, in terms of which I am being approached, does not provide me the competence to deal with the matter on any other basis than the specified grounds that are alluded in that section. I have a petition before me, clearly set out in terms of that provision, and therefore I am limited to what Section 327 tells me to do and the grounds on which I can do it. I do not have competence in dealing with this matter at this point beyond the provision of that section, because that is the only matter at this point that is before me. Thank you.
I will assume, ladies and gentlemen, that this is all that you had to ask, given the well-crafted and well-researched media statement that the Minister has read out, which covers all the issues and concerns that you have, hence the few questions. Lizelle in Cape Town, thank you very much. Pretoria, thank you very much for your patience. And like I indicated, the Minister will not be indulging you on any one-on-ones. This is the detailed statement and comprehensive statement that we provide to you. Thank you very much.